I'm Jaewon Kong, reporter with The Deal, and joining me today to talk about Delaware law is senior writer David Marcus. David, 2014 was a busy year in Delaware law. What were some of the personnel changes we saw?
So on the Supreme Court, we have 3 new justices out of a total of 5, and we're going to get a 4th new justice early next year. The most important of those new justices is Leo Strine, who had been on the Court of Chancery for about 15 years before he was elevated to the Supreme Court. So we have a pretty good sense of his jurisprudence, but the fact that he's now on the Supreme Court may mean that he's more likely to take appeals on issues where he thinks the law can be further developed. And because 3 of the other 4 justices will be new, he may have more sway over those justices than he might have. Replacing Strine as chancellor is Andre Bouchard, longtime Delaware lawyer, and he's, even in the 7 or 8 months he's occupied that spot, he's done a terrific job. He writes crisp, clean opinions. He is conservative jurisprudentially, but not afraid to set out after behavior that by companies and directors that's dubious.
Interesting. And what were some of the most notable and influential cases we saw this year?
So I think there are 2. And the first one was the ATP decision from the Supreme Court in May. ATP said that so-called fee-shifting bylaws are legal. Now that's sort of an arcane term, but what it means is that a company can have a bylaw that says that a shareholder who sues the company or its directors for breaches of fiduciary duty and loses has to pay the company's legal fees, which of course would put a chill on that kind of litigation, which is a big part of Delaware litigation. The Delaware bar, both corporate and defense side, essentially tried to rewrite Delaware corporate law to make those bylaws illegal. The Delaware Senate did not end up doing that because of lobbying from corporate America, but that issue remains very unsettled, and it's one that we should continue to look for in 2015, both any legislative responses to fee-shifting bylaws and the contours of fee-shifting bylaws if it turns out they're legal. The other important case was Vice Chancellor Laster's decision in Rural Metro, where he found that Rural Metro's bankers aided and abetted a violation of fiduciary duty by the company's, Rural Metro's bankers, aided and abetted a violation of fiduciary duty by the company's directors in the sale of the company to Warburg Pincus. This was a fairly aggressive decision under Delaware law. It's caused a lot of consternation in investment banking circles, and this too is something to watch for next year, both in terms of the development of the doctrine by other members of the Court of Chancery and perhaps by the Supreme Court. This is an issue where Chief Justice Strine may be interested in stepping in.
All right, we'll be watching. Thanks for joining us. I'm Jaewon Kong, and that's The Deal.